welcome again. We conclude our expose of the deceptive and criminally motivated campaign to class all people who resist unlawful action by those falsely claiming Crown authority as sovereign citizens by amplifying the concept of constitutional law and considering how we may more effectively spread this concept to the general public. It is undeniable that the vast majority of people know virtually nothing of the Constitution or even of its existence. This situation has been contrived by centuries of skillful manipulation of people's emotions, which of course then affects to a huge extent their actions. Let's consider some more thoughts from Spinoza, whose work Ethics comprises an extremely broad consideration of the human condition. Quote, "Further conceive, I beg, that a stone, while continuing in motion, should be capable of thinking and knowing that it is endeavouring, as far as it can, to continue to move. Such a stone, being conscious merely of its own endeavour, and not at all indifferent, would believe itself to be completely free, and would think that it continued in motion solely because of its own wish. This is that human freedom which all boast that they possess, and which consists solely of the fact that men are conscious of their own desire, but are ignorant of the causes whereby that desire has been determined." Unquote. We saw evidence in the video clips in this mini-series of the use of emotive wording, mockery of dissenters, and the exercise of violent power by people posing as constables. When we consider the word constable, we see that it comprises two parts, con and stable. Con is a Latin root meaning with, as for example in conspire, meaning to breathe together. Stable is also of Latin etymology, meaning firmly placed, steadfast, well balanced, etc. Thus, the word constable literally means one who is charged or defined as being a keeper or maintainer of the peace and stability of the community as a whole, and hence the strong emphasis on the concept of maintaining the peace, which winds as a binding thread through the constable's oath we discussed last week. It is placed on screen again as a reminder. What we saw in the video clip of the alleged constables acting violently and themselves deliberately violating the peace in open violation of their oaths is a clear indication that they were actually displaying power, not authority. Authority derives from a position of morality. When a criminal is apprehended by officers of the law, there is no questioning of authority because all in the community are aware of the standards of conduct to which everyone consents, that is, to do no harm to each other. On the other hand, when no harm has been done and the officers act violently or aggressively against otherwise law-abiding subjects who are merely questioning whether these officers are abiding by their oaths or are lawfully entitled to act as they are doing, then there is a problem. But it is not with the subjects, it is with the officers. They are displaying power, which is another thing entirely from authority. For those officers and those whose orders they are unlawfully enforcing, to resort to such oxymoronic epithets as sovereign citizen is an open admission of the intellectual and moral bankruptcy of their position. If they truly had authority, violence would not be an option, unless it were, for example, used in self-defence against criminals resisting lawful arrest. In the case of those people whose car window was unlawfully destroyed, the correct option would have been for the superior officer requested to be made available, and a peaceful discussion could have ensued, which might have ended in a summons to appear in an unlawful court, but probably without violence ensuing. One might indeed question the wisdom of the approach used by the car occupants. It could have been worded more effectively and less confrontationally, perhaps consisting more of questions than a series of assertions, but that doesn't excuse the violence of the officers involved, especially if they wish to honour their constable's oaths. The major implication of the car occupants' assertions is clearly the questioning of the officers' authority and the fact that they were allegedly acting unlawfully. Of course, the officers' response is that they are acting legally, which is a totally different thing. But it's doubtful from the subject's statements that they knew this difference or were at least able to express it coherently. However, the word constitution derives from the Latin root constitutio, which means the state of a thing, or of what a thing consists. The British Constitution defines the state of how the law is established, or it is the state of things pertaining to the relationship between the participants in the established order of community interactions, namely the parties to the treaty established in 1215 between the monarch, his peers the lords, and the subjects. This is often claimed to be unwritten, which is untrue. Magna Carta is clearly a written document, and the protestations of lawyers, judges, or magistrates that it is not, or is no longer in effect, cannot negate the fact that copies of it are in existence, or that Article 61, for instance, was invoked in 2001, or that Article 39 states that no one shall be subjected to summary or arbitrary punishment without a trial by jury of the accused peers. The Constitution binds the government, namely those placed in office to administer the affairs of state and the law, with strict guidelines as to how they may conduct themselves. And contrarily, these restrictions in general don't apply to the subjects, who are free to behave as they wish within the bounds of the common law, which is agreed by all. Everyone is subject to the Constitution. The only difference is in the degree to which it applies in individual lives, with the greatest restrictions placed on those entrusted with the exercise of power. Generally, the impact on the subjects is minimal, except when the monarch or the appointed administrators behave unlawfully, as for example in committing treason. At that point, the subjects are also placed under specific instruction as to how to conduct their affairs in relation to their involvement with the state. And these instructions are outlined in detail in Article 61. Those who fail or refuse to obey these instructions thereby join the monarch or the other administrators in failing to uphold the Constitution, and merit the same condemnation and negative outcomes as those other parties. Freedom comes with certain responsibilities. It is not a question of every man for himself. the obligation is to do one's duty, just as it would be if the nation were attacked from without in a war. For delinquent public officers to resort to malicious, fictitious name-calling of subjects seeking to call them to account for malfeasance is merely to compound their crimes and the resultant severity of their punishment when lawful authority is eventually restored. If there be some subjects with incomplete understanding of the Constitution who do indeed claim to be immune from the law, remembering that those claiming to be government always refer incorrectly to legislation as law, then those people need to be educated in the matter. Descending into brute violence against such people, or labelling as potential terrorists and troublemakers anyone who has any questions to ask of the behaviour of public officials, irrespective of the validity of those questions, is an egregious offence against the very concepts of morality and justice. By such immorality, the perpetrators of such slander and violence condemn themselves out of their own mouths. Returning to the question of why so few people know anything about the Constitution and its importance, and what we might do to rectify that situation. Recently, William Keat has appeared in 3 video conversations with Richard Vobes and another with historian Neil Oliver, in which this issue was discussed in detail. I highly recommend accessing these interviews, the links to which are in the comments box. Will also makes available a website, commonlawconstitution.org, which has masses of information about the Constitution and plenty of memes which can be copied and posted, as widely as possible please, to spread this knowledge as fast and as far as possible. As Will points out, once there are hundreds of thousands of people all talking about the fact that there is a valid, lawful mechanism by which these imposters masquerading as a government can be held to account, and posting information about these things far and wide, the moment when there is a tipping point and those currently ruling the roost realise that the game is up and start to make concessions, will approach much more rapidly. A key point made in Richard and Will's interviews is that the knowledge of how our Constitution and concepts like annulment by jury are supposed to work has been hidden deliberately for centuries. And along with that obfuscation has been the surreptitious nudging of opinions and desires of people to get them to go along with the deception alluded to in Spinoza's words at the beginning of this talk. Here's another more succinct expression of that concept. It's in the nature of human beings to seek the path of least resistance when dealing with problems, especially everyday issues, such as earning a living, resolving family disagreements, as well as broader issues, such as how to deal with social problems like unemployment, education, health, disability, the economy, and so on. It's relatively easy for politicians or demagogues to offer platitudinous solutions to these questions, with the implications, indeed often openly expressed, that the government will take care of all that, leaving, quote, ordinary people, quote, free to get on with their lives. There's another of those psychology-based phrases nudging people towards acceptance of the idea that they're not really capable of solving these issues under their own steam, and it's much more convenient to let the experts deal with these problems, subtly relegating themselves to a position of intellectual, even moral subservience. We've even seen in recent years and months the mass of people yielding, as bemoaned by Sky presenter Rowan Dean, the question of what is the morally right thing to do on important issues like responses to health to the government rather than their own consciences. Should a person refuse to undergo mandated medical procedures, the effectiveness of which may cause them grave concern, on their own volition? Or does it somehow make it less of a problem to just do what the government says, thus avoiding any immediate blowback about resisting something which our conscience is telling us doesn't really sit right with us? The problem with this compliant attitude, as Will Keat has expressed and which I heartily endorse, is that it leaves us with unresolved contradictions in our thinking. There's that doublethink again. On the one hand, people are inclined to say that they feel relatively comfortable and well off, especially compared with previous generations, regarding physical standards of living. So why rock the boat by going up against the powers that be? On the other, there's this growing sense of unease that somehow the actions of the alleged governments, courts and police forces are edging uncomfortably close to the point where many people are starting to feel it necessary to say or do something to resist these incursions into our philosophical and moral freedoms. The question is, what? And the longer these issues remain unresolved, the more certain it is that unresolved questions lead eventually to non-preferred or undesirable outcomes. We've all heard of people who got indicators of a possible serious health issue and ignored them rather than face the issue, with calamitous results. It's exactly the same principle when the sickness is manifested in the body politic as in the individual. Collectively, we can't afford to leave it too late. Get on board, learn the material, understand it, and start acting on that understanding. Until next time, thank you for watching.